All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here now for CV 22-0318, Mirabella at ASU versus et al. Versus Peacock's Unlimited. As I imagine you know, this is being recorded and currently live streamed, so when you stand up, please announce for yourself and your client. You have a maximum of 20 minutes per side. We don't require you to use all of that time, although I would imagine you will be likely to do so, so feel free. But if you would like to save time for rebuttal, that's on you to figure out. Or if there's any split of time that's occurring. Okay, that's easier then. Keep in mind, please, we have reviewed the briefing and the record. We've discussed the case in conference. And with that.
May it please the Court, Scott Swillinger and Jennifer Allen for Shady Park, Peacock's Unlimited, doing business as Shady Park. It is, of course, the rule that injunctions must be narrowly tailored to eliminate the harm that's alleged. And here, the injunction that was issued by the trial court is not narrowly tailored. The first place we see that is in what I'm going to call the curfew. The prescribed time that music is permitted to be played outside Shady Park in its stage area.
Counsel, so I know that in general we review preliminary injunctions for an abuse of discretion. Does the existence of a constitutional challenge and the standards that we apply, the sort of more rigorous analysis we apply under the First Amendment to an injunction, does that change our standard of review, or are we still within an abuse of discretion framework?
Because it is a complete ban on speech, the standard is heightened, but we are here on an abuse of discretion standard, and I think as we work through it, it doesn't really matter. Okay. Because when we first talk about the curfew, it is a complete ban on speech. Of course, the complaint concerns the claim that music played by my client is a nuisance. And the injunction contains certain restrictions to address that nuisance, and we think those are flawed, and I'll talk about them.
If it's a complete ban on speech, why did you guys not raise the First Amendment until way too late in the whole process?
Well, respectfully, Judge, it wasn't too late. The first time that the First Amendment was implicated, we raised it. The case began with the statement made by the plaintiffs that they're not looking to shut the music down at Shady Park, that they're simply looking to address the volume and the noise that came out, the sound, the music. When the First Amendment first became implicated was when the Superior Court put a ban on music on any time after 11 o'clock during the week and after 7 o'clock on Sunday. And
so are you saying that the First Amendment and the free speech implications only arise when there's a complete ban, as opposed to if music is speech, wouldn't other restrictions on that speech also give rise to First Amendment concerns?
Well, we acknowledge that if Shady Park was a nuisance, we don't think it is, to be clear, that it does not implicate the First Amendment. You don't have a First Amendment right to create a sound nuisance. So that was never an issue, because the issue was they wanted the volume raised. Throughout the case, when the judge asked a question about it, Mirabella's experts said, well, no, we never even considered that. Each of the plaintiffs testified in side declarations that they weren't looking to stop the music. And in fact, the record shows that at the end of the case, the court said this is not about stopping the music. So it was never implicated until the injunction was issued.
But what if the court had decided to lower the decibel limit way lower? I mean, wouldn't you then be concerned about a First Amendment issue that's not narrowly tailored?
Well, no. If it's simply a volume issue that and the cases talk about the cases that talk about abortion protesters and the loudspeakers, and you can't shut them off. That's not a First Amendment issue dealing with the decibels and the volume. It's the statement that you cannot play any music after 11 o'clock on a Friday or Saturday and after 7 o'clock on a Sunday. It's a complete ban on speech, and music is a form of speech, it's a form of expression. So the First Amendment protects our right to do that. For example, Shady Park is going to have a comedy show, not a strict music concert like it's used to. It can't, if it's after 11 o'clock, it can't play walk-up music for one of the comedians, or closing music when the comedians walk off the stage, because it's simply after 11 o'clock. if it wanted to have piano during lunch, a background music of a brunch. It can't do that before 7 o'clock.
So your argument then, if I could rephrase it, and correct me if I'm wrong, is that we didn't raise the First Amendment because it never occurred to us that someone might actually violate it in doing this. That no one had sought any kind of relief that we thought might violate the First Amendment, so we didn't think we needed to raise that issue.
Well, I think more than that, it was rejected. It was a statement from the plaintiffs. We're
They
not
explicitly disclaimed it.
Yes,
Yeah.
exactly. And so why would we raise it? And the moment it was raised, we raised it to the Superior Court, we raised it to this court, and now we're here raising it on appeal. So respectfully, we didn't waive that argument. We didn't wait. The moment it was there, we jumped on it because there's a big difference between arguing about decibels and bass and speakers and numbers of that and saying you cannot have any expression for music except for this very limited amount of time.
Let's say that we agree with you that the curfew specifically has First Amendment problems, but of course the Superior Court was not considering that during the hearing. I did some word searching. There was not any discussion of narrow tailoring or least restrictive means or First Amendment. So would we have anything that we would do in the first instance, or would the answer to that be to send us back to the Superior Court to, in the first instance, consider its terms, including the curfew term, under the rubric of a First Amendment analysis?
We asked the Superior Court we asked the Superior Court after the injunction was issued to reject the whole injunction and reset the matter, but we did raise the First Amendment to the Superior Court at that time, and at that point...
I saw that you raised it in the motion to stay. Was that also a motion to reconsider? Or?
It wasn't labeled a motion to reconsider. It was a motion, but it raised the First Amendment issue the first time to the Superior Court. At that point, Judge Ostrowski had recused himself, and our new judge had taken the matter, and so it was denied. But it was raised to the Superior Court and then raised to this court on our emergency motion.
But what relief are you asking for? Are you asking for us as a matter of law on this record to determine that it violates the First Amendment, or shouldn't that be determined in the first instance by the Superior Court? Yeah, a judge has not looked at this, except maybe briefly in your motion to stay.
I think part of the problem was the recusal led to a judge who's sitting there coming into a case, that's been tried, and he...
Well, exactly. So why, if we were to agree with you, why wouldn't we just send it back and say, take another look at this?
Because it was raised below, and the court rejected any motion to stay its order to even allow us to appeal to you, and now it's in front of you. It's a clear violation of a civil liberty. There's the argument's put on the other side that the First Amendment...
What is the civil liberty that's violated? Is it the right to play music, the right to play music outdoors? Is it the right to play music outdoors after a certain hour?
The right to play music in the way it's otherwise permitted by law. All the places in Tempe or around the state of Arizona can play music unfettered to 2 a.m. We cannot. We can only play it from 7 to 11. That is a complete...
Do you guys have an indoor stage, or is it only outdoor?
It's only an outdoor stage. Inside is a restaurant, and in the back is an outdoor stage. So the right is a right of expression, the right to play music, and I think that it's pretty clear from the case law, the courts that have considered music, there's no decisions that say music is any different than any other type of speech. And here, it's the fact.
How about EDM? Is that still considered music?
My client would say yes, and I agree with him, but the point is, that's the point. It doesn't matter if it's EDM music. It doesn't matter. I think they took a shot at us about Rachmaninoff and Tempe or something like that, but it doesn't matter the kind of music. Nothing can be played. And when we're talking about EDM, it's when you think about it, it's not traditional, a band up there with the drums, but music's coming out of a DJ by speakers. So where's that line crossed? We can't do anything except have silence, and that violates the First Amendment. And so that requires, as a matter of law, that portion of the injunction be vacated.
So is that you would have us vacate, so effectively amend the injunction to remove that offending portion?
I would say strike it, but I think it doesn't matter the term you use. But yes, that's correct, that portion runs afoul of the First Amendment and is ineffective and should be struck.
So there's a rule of civil procedure that grants the Superior Court the ability to amend and rewrite, rework injunctions on a going forward basis. Do we have that specific authority somewhere? We're a court that's bound by statutory
Well,
authority.
we've appealed the entire injunction, and I do think the entire injunction is flawed, and maybe that solves your concern, because the rest of the injunction, if I may, deals with the fact that a bias, the ignoring of evidence. Nuisance law is a balancing test. It presents whatever court deals with it to balance the noise that's being made, the sound that's being made, the people and the annoyance that they feel with the context of the area. So it's not simply, and the cases from California that we cite explain this, simply because you're annoyed does not create a nuisance. What matters is the context. And here, the context was removed by the Superior Court, and it was removed for a legally flawed reason.
Wouldn't we need, I mean, I'm very hesitant to, assuming I agree with you on the curfew side of it, to just vacate that part of it and send it back, because it's, as I read the record, it sounds like the Superior Court kind of gave you guys the benefit of the doubt on the decibel level on the A range, used your experts, when their expert had said there was be a lower decibel range. And I could see a Superior Court saying, okay, if I can't apply a curfew because I need to apply the least restrictive, but I'm going to, after 11 p.m., say the A range can't be higher than 62 or whatever their expert had said. So if we just vacate the curfew part of it, what do we do? What's our remedy to let the Superior Court go back and do all that balancing that needs to be done?
Well, I think there's two answers to your questions, Judge. First off, I think because of the violation of the First Amendment, the whole injunction is flawed and should be set aside and the matter remanded to the Superior Court. But if you're inclined, if you're looking for additional reasons to support that, when we talk about the balancing test, the fact that it was not balanced properly, that all of the evidence from anybody who worked or was, worked for the city of Tempe was just thrown asunder and not considered, means that the balancing test wasn't done properly. It was done in a way that is an abuse of discretion.
We generally don't reweigh findings of bias or the Superior Court's decision to find witnesses not credible. So I'm not very persuaded, but feel free to make your best case.
And I agree with you. I'm not here to tell, if this was a case where we were arguing, one witness said it was clear, one witness said it was cloudy, and who's more credible and who is believed, I agree with you. That would be improper in the posture in here with an injunction. But what we're saying is that the evidence was simply said, I'm not going to consider it because I find bias, and I find bias because a witness testified difficultly with defendant as opposed to us, or I got that backwards, or because the city of Tempe acted and set aside one of its sound code, which had been in play for 10 years. And so the Superior Court said, I'm not even going to consider it. And how do we know that? Well, the best evidence of this matter are the body cams. They are contemporaneously captured by police officers. Now, if you want to say the assistant city manager was biased, I vehemently disagreed. But there was no evidence that there was a bias from police officers, nor could a body cam be biased. And when the judge didn't even consider what those body cams showed, and when, had they been put on the scale, at least it should have been considered. The court had to address it and balance it as part of the injunctive process. The other place was, even when the body cam evidence completely contradicted testimony, the Superior Court ignored it and didn't place it on the scale as part of the balancing test. And I'm referring to the testimony from the assistant manager of the Canopy Hotel, who testified that walls were shaking, music was being played, and the police never showed up. And then, as you saw in a brief, there was video cam of the police showing up, the walls not shaking, and no sound being played. So none of this was addressed, and it was all under this lens of bias. But there's another legal reason, and that's deference. The court, in its findings of fact, adopted 20-11 to Tempe City Sound Code. So this is a reasonable standard. And it applied that because of McQuaid, and McQuaid talking about balancing context and where and how you measure sound. And then, even though it adopted 20-11, but I'm not going to even consider what Tempe found. And having adopted 20-11 as part of his ruling, the Superior Court should have at least given deference to the city's findings. But the court looked behind the curtain and said, I'm going to find bias because of the testimony of a single witness and the fact of a unanimous legislative act after after trial occurred in this matter, and declare everything biased and not put it on the scales. And so that's different than simply saying, I didn't find this witness credible, I found this witness credible. It's, I'm going to declare bias, go invade the city of Tempe's police powers and not even consider the evidence.
Your separation of powers argument I find interesting. So if Tempe had found an ordinance, you wouldn't be appealing because that should be their exclusive purview?
I'm sorry, if they had found?
If had found a violation that you guys had created a nuisance, we shouldn't look at that either?
No, well, if it had been considered by the Superior Court, yeah, no, I would be asking you to consider it, but they considered the matter, they found no violations, and the court took
We
that.
have to defer to that.
It has to be at least considered, and it should be deferred to, and not said, I'm not going to question it because a witness testifies in a manner that I think is biased, so I'm going to throw all the evidence from the city out. And that, I think, led to this, for me, a significant act of the amicus brief that was filed in this matter. That the city of Tempe took the step to say the judge didn't listen to us and didn't agree and found that the error.
You characterize it as a separation of powers argument, meaning that we should not have any authority to review the appropriateness of the city's. Once the city has found that you guys aren't a nuisance, we have to defer to that.
No, I'm not saying that the city controls, that the case is over, we should have won summary judgment. What I'm saying is that the reason, you can't look to the bias. You can't say the city was biased in favor of this because of this fact or that fact, and therefore I'm not even going to consider the evidence. It had to be placed onto the scales of the balancing test that has to occur. And the case law talks about the courts are not going to look to that. I mean, every decision of every city, council, legislative act has some bias. If there's improper bias, there's ways to address that. If Mirabella felt it was improperly biased, I suppose they could address it with the city and Tempe in multiple ways. But that doesn't mean the court can simply ignore it and not include it, particularly when in a nuisance action, the context is so key. If Shady Park was in a 100% residential area of Tempe, this is a very different case. But we're talking about Mill Avenue. We're talking about...
Did you challenge the Superior Court's factual finding that it was a residential, predominantly residential area?
We did in the lens of the ignoring of the evidence, the fact that they're not going to consider it was a legal violation. I couldn't be here saying to you, the court heard this as it was presented, in this regard, it disagreed and found that. I agree with you that that would be improper at this stage, although we vehemently disagree. But what we're saying is it was never considered, it was wholly ignored. And it wasn't like there was evidence presented that Mill Avenue and the downtown area is not a bustling area, mixed-use area with nightlife that is noisy with college students to 2 a.m. and beyond. The court mischaracterized by ignoring the city of Tempe's evidence, which led to the amicus filing. And unless the court has further questions, I'll reserve the remainder of my time.
Thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Matt Jarvie. I'm with Andrew Jacobs, Snell and Wilmer. We represent Mirabella at ASU. We're joined today in the gallery by Matthew Kerner of Perkins Coie, who represents the individual appellees, but I'll be giving the argument on behalf of all the appellees this morning. The Superior Court in this case did exactly what Superior Courts are tasked with doing in cases like this. It carefully considered a detailed factual record, and it crafted an injunction designed to balance competing interests on both sides of the equation.
Did any of your clients or joint clients request a curfew?
Yes and no. From the outset of this case, from the First Amendment complaint, one of the alternative remedies we asked for was a complete injunction, so a total curfew, if you will. So from the outset of this case, to the extent that Shady Park is claiming that a restriction on their concerts is a regulation of speech, this case always, from the beginning, had the possibility of a total restriction on speech. Then at the actual injunction hearing, the Superior Court broadcast to the parties that it was considering crafting an injunction.
How so? But simply by asking a witness whether it was possible?
So on the second day of trial, during our case in chief, during our acoustics expert, Mike Dickerson, the Superior Court asked Mr. Dickerson a series of questions. It's at page 86 of our appendix. And one of the things that the Superior Court flagged in that questioning was he used the word potential solution. He called it a potential solution in this case.
But didn't the court then later say, that's not before the court, we're not considering that?
No, Your Honor. I think later on, the court said this case was not about shutting down totally Shady Park, and that is the position we took at trial. But the court made explicit on page 86 of our appendix that it was considering a potential...
Do you dispute what your colleague said about the affidavits and the witness statements all explicitly disclaiming a request for a curfew?
We don't dispute that the affidavits didn't request a curfew, but the parties were on notice the moment the Superior Court said, I'm considering a potential solution in this case that involves a curfew, and then asks our expert witness, would that help people sleep if I set a curfew, normal hours? And our expert answered yes.
Did the court also ask, wouldn't lowering the volume down more after 11 o'clock, would that help people sleep?
There was a number of things, correct, Your Honor, that the court asked about. But the point is...
So your position is that one question should have put them on notice that they need to stand up and say, hey, First Amendment, right then?
Not necessarily right then, but we had several more days of trial where they could have raised a First Amendment objection. They had a written closing argument that was after the hearing. That
And
they could have.
Did your written closing argument ever request a curfew?
We did not.
Okay. So you want them to remember that statement 3 days later and then do a preemptory analysis of First Amendment issues before the Superior Court at that point?
Because the Superior Court flagged that it was...
Ask one question.
Well, the one question...
Was it one question?
The one question, correct, with Mr. Dickerson, but then also talked about...
But then later said, but I'm not talking about shutting you down.
Correct.
Okay.
And also explored...
I know you guys spend a lot of time in your brief saying this is a waiver, but it seems to me that the first time they really realized that there's going to be a curfew was when the curfew was issued, and then they promptly raised a First Amendment issue, didn't they?
Well, our position is that they didn't promptly raise it because they were on notice.
Once the curfew was issued, they raised it promptly.
Well, they raised it about a little less than 2 weeks after the injunction order issued.
All right.
But going back to the beginning of the case, back to the First Amendment complaint filed back in October of 2021, to the extent there was going to be any First Amendment objection, to the extent that Shady Park was going to object that we were seeking to curb their speech acts, their free speech, that curbing would have been logically at issue back as far back as the beginning of the case. Because whether it's a request to turn down the volume, in their words at page 18 of their brief, degrade the music that they're playing, or whether it's a request in the alternative, which we did make in the First Amendment complaint, to be a complete injunction against concerts, that should have triggered whatever First Amendment concerns they had. And that's vastly before we ever get to the preliminary injunction.
Do you have any good
hearing.
example of a case in which a court has affirmed a unconstitutional injunction against speech because it was waived? No one raised the First Amendment?
Off the top of my head, I can't, Your Honor. No.
Counsel, a couple of questions. First, is this going to be revisited soon at trial?
It probably will.
Is trial still set for?
End of February, early March.
So, and you agree that waiver is non-jurisdictional? It's not a jurisdictional
Correct.
issue. So, in our discretion, we could look at it.
You can. Even if this court goes past waiver, though, on the First Amendment issue, there's still a couple of other threshold problems, or one threshold and one substantive on the tailoring. The second, if you will, threshold problem is whether the speech is protected in the first place. Mr. Zwillinger conceded, as I think he must, that a nuisance is not protected speech. And Cactus Corporation, that case makes that clear. It belongs to a category of speech that just simply isn't protected by the First Amendment because it's speech or conduct that is independently tortious or criminal. It's likened to things like perjury or defamation or fraud, things that are technically speech acts, but because they are independently a crime or a tort, don't garner First Amendment protection. Again, I'd refer the court to Cactus Corporation on that front. Even if we go to the third layer, we'll call it the substance of the tailoring issue, we're talking about intermediate scrutiny. And I think that's important to emphasize. We are not talking about strict scrutiny. The case law is clear that it is not least restrictive means. Least restrictive means is not the test. And I'll direct the court to the case of Sharkeys versus City of Waukesha that both parties cite in their brief. I'm quoting, "The requirement of narrow tailoring does not mean that regulations must employ the least restrictive means.
Well, let me talk to you a little bit about the United States Supreme Court's decision in Madsen, where the court said that in considering a First Amendment challenge to an injunction, that the court seeks to ensure the injunction is no broader than necessary to achieve its desired goals, and that when we evaluate that injunction, we look to whether the challenged provisions of the injunction burden no more speech than necessary to serve a significant government interest. As to the first part of that quote, who decides what the goals are? Is the articulation of the goals of the injunction yours to make in your initial request for an injunction? Or is that the court's?
Our position would be that it's the latter. It's the court in crafting an injunction.
Decides the goals.
Decides the goals, just as the court did here, specifically in paragraph 45 of its findings of fact, where the court says that all three substantive prongs, the time restriction, the decibel limitation, and the rearrangement, reconfiguration of sound equipment, all three of them were necessary to mitigate Shady Park's nuisance. So in doing so, the court essentially said that these three prongs, all three of them are necessary, in my view, to affect the goal, the purpose of the injunction.
How can the court say that when your own expert said that a 62, and I'm making up the numbers a little bit, the 62 level limit on the A-range noise would abate the nuisance? What evidence was there to support the idea that we had to shut it down after 11 p.m.?
Sleep. Sleep was one of the predominant irreparable harms that was discussed.
Was there testimony or evidence that at that decibel level it was not possible to sleep?
There wasn't. There was testimony, however, and argument, especially from Shady Park, that essentially any turning down of the volume was tantamount to being
right, but your expert said 62, and again, I might be misquoting the number, 62 would abate the nuisance. Do you dispute that?
I don't, Your Honor.
Okay, so there was no evidence that allowed the Superior Court to determine that it was necessary, whether we're talking about least restrictive or just the nuisance standard, there was no evidence upon which the Superior Court could reasonably rely to say that it had to shut it down to abate the nuisance.
What the Superior Court was attempting to do with the 11 p.m. cutoff was strike a balance.
I know what the Superior Court was attempting to do. Was there any evidence to support that?
When the Superior Court asked our expert, would an 11 p.m. curfew allow folks to sleep normal hours, and our expert answered yes. That's a basis in the record for why the Superior Court was looking at a curfew as opposed to a decibel limitation. Shady Park argued all along that any essentially...
Right, we're not arguing that point.
But I understand. That's what the Superior Court was confronting, though, in crafting its injunction. It was trying to strike a balance between two different parties, one who didn't want to turn down the volume at all, one who wanted a more restrictive injunction than the Superior Court issued. And the essence of tailoring is the Superior Court crafting that middle path that it did with the preliminary injunction to give weight to either interest on both sides of the equation. So under the injunction, I want to be clear about this. It is not a complete ban on music. It permits music and loud outdoor concerts 7 days of the week for 4 to 5 hours at a time every single day. It is a limitation.
I mean, we're kind of playing semantics there, aren't we? Because it is a complete ban for the other, 19 hours of the day.
Only on outdoor concerts. And the court went to great lengths to say at least 7 times in just the injunction portion of the court's order.
But that's what's at issue here, right?
Well, the evidence was that they held outdoor concerts, but if they wanted to engage in other forms of speech, including musical speech, concert speech, they could host it indoors. There
was testimony to that effect, that they had a venue to do that?
Well, they have a venue. They have a premises, a bar and restaurant.
Was there testimony about holding indoor music of any kind?
There was not.
Okay.
Their venue is an outdoor venue, but one of the things the court can consider, and in the intermediate scrutiny balancing test, one of the things courts do consider is whether there is ample breathing room for other avenues of having speech.
I just want to make sure I understand your argument. You're acknowledging that there is at least a First Amendment issue in play here.
If the court gets past waiver and gets past Cactus Corporation, yes. The third level, yes.
Okay. And what exactly is the intermediate scrutiny that the court should have applied if we get to that third level?
Sure. I'll refer the court again to Sharkey's, which quotes Ward versus Rock Against Racism, which is a U.S. Supreme Court case that
Right,
Sharkey's.
but the Mattson case, the U.S. Supreme Court rejected the Ward standard because the issue there was an ordinance and not an injunction. So that's my concern with that.
Fair enough. Let me go right to Madsen then.
Okay, thank you.
Madsen supports the injunction here because, as the court will recall, there were several prongs of the injunction at issue in Madsen. And of those prongs, one of the ones that was affirmed under the First Amendment is a prong similar to the injunction at issue here, a time-bounded noise restriction. That, in Madsen, it was picketing outside of an abortion clinic. So we're talking about a speech in Madsen that's a little bit more at the center of traditional core protected First Amendment speech on a political issue, on a sidewalk, a traditional public forum. But the court there issued an injunction that limited singing, chanting, speaking, limited the amplification of the singing, chanting, speaking, and put a time boundary on the protesters. And of all the prongs that the Supreme Court analyzed in Madsen, that one was affirmed. That one passed First Amendment muster.
Do you know whether the folks petitioning for the injunction in that case requested that time restriction?
I don't recall that, Your Honor. Yeah. But whether they requested it or not, the court said that constitutes appropriate tailoring in that case and overcame the First Amendment objection. So in intermediate scrutiny land, which I think is where we are, there's a certain amount of breathing room that has to be given to a court to again, balance the interests on both sides of the equation as the court did here. I want to turn to the argument.
I'm sorry, I think Judge Perkins had some great questions there, but I think it may have distracted from, what is intermediate scrutiny? What is that, what is that standard that we apply?
Again, I'll go back to Ward versus Rock Against Racism. The requirement of narrow tailoring is satisfied so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation. I don't think there's a question here that we're talking about.
And the substantial government, and I'll put on the hat of an advocate for a second, and the substantial government interest is preventing the nuisance in this case.
The substantial government interest is protecting the tranquility of the home, which the U.S. Supreme Court has said is an interest of the highest order.
Right. And your expert said there is no, that would be accomplished by lowering it to 62 decibel levels on the A range.
Yes, with the other things our expert said as well, including the differences between A-weighted and C-weighted decibels that have been no more than a 15 decibel difference between A and C-weighted.
So how do we affirm the court going beyond that?
There is, in intermediate scrutiny, in the world of intermediate scrutiny, there is no one line, one platonic ideal of a perfect injunction or a perfect line that has to be drawn. There is a bit of breathing room, not as much as rational basis, less than strict scrutiny, but there's no one perfect formulation of an injunction that the Superior Court has to find.
So there doesn't have to be some evidence in the record to say that this is necessary or at least helpful in achieving that?
There was ample evidence in the record that people can't sleep. They cannot sleep in this neighborhood. And so setting a curfew, which in the court's own words, allows folks to sleep normal hours, is imminently based in the record. There was testimony not just from the Mirabella residents, there was testimony from 2 college-aged people. They can't get to sleep. There's testimony from the 2 hotels that surround Shady Park, that the hotels are moving people to other rooms at the opposite side of those hotels to get away from Shady Park concerts. They're receiving something on the order of 6 to 9 complaints every single weekend. So the idea of the Superior Court protecting folks' ability to sleep or to simply enjoy tranquility in the privacy of their own homes, that's why the court drew the line at a time cutoff. And the court was permitted, under intermediate scrutiny, to draw that line in its discretion informed by the evidence.
Counsel, what about the argument raised that the court here completely disregarded all the evidence that related to the city of Tempe? Would you address that?
Sure. The court heard all of that evidence. The court heard testimony from...
We know the court heard it. What did the court do with that? What evidence in the record indicates that the court actually considered it or weighed it appropriately?
Well, the court, first of all, took it into evidence, didn't exclude it, and so heard that evidence as part of the hearing, and the court referenced it in the court's order. The court didn't give as much weight to it as the court gave to...
It was as much, or did the court give it any weight?
Well, the court certainly considered it because the court discusses it in paragraphs 38 and 40, for example, of the preliminary injunction order. So the court absolutely confronted that evidence, but held that it wasn't entitled to much weight. Mr. Zwillinger...
Well, 38 and 40 are the paragraphs in which the court specifically says the city is biased.
Correct.
I guess I read those paragraphs precisely the opposite of the way that you're sort of portraying them here, which is that the court was saying, yes, I heard this evidence and I reject it because I think this witness was difficult.
What I was responding to is the notion that the Superior Court ignored evidence. The Superior Court took on that evidence and found it lacking in credibility for reasons cited to the record in paragraphs 38 and 40. And of course, it's the role of the Superior Court here to weigh credibility. Credibility is just something that goes to the weight of evidence. And here the Superior Court considered a number of things, bias and non-bias, related to the city's lack of enforcement of the Tempe City Code, and simply found the ample evidence on the other side of the equation outweighed it.
Is there anywhere else other than the paragraphs in which the court is sort of rejecting the city that you could say the court pointed to any weighing of the evidence that the city put, that the city...
Just that we think the court confronted it as part of drafting its preliminary injunction order, and it's inherent, we think, in the court's crafting of the order.
So, counsel, I should know the answer to this, but I don't. So, did the parties submit proposed conclusion or proposed findings of fact?
Both parties did.
Okay.
That's right. I'd like to address briefly the notion that Shady Park is challenging the character or nature of the surrounding community as being, as the Superior Court found, principally residential and non-music commercial. There was ample evidence in the record that was the character of the particular locality. Shady Park, the evidence showed, is smack dab in the center of residential buildings. On the south side is Mirabella. There are a couple of apartment complexes surrounding it, and there are a couple of hotels surrounding it.
Would you agree with me that ASU, Mill Avenue, apartments and dorms perhaps might have a slightly different character than North Phoenix or Chandler? I mean, I think that's the point that's being made is, yes, there are apartments. There are also EDM clubs and other nightclubs, and all of that is within this immediate vicinity.
We think it's a factual issue. It is not determined by saying this is the city of Tempe. It's not determined by saying, hey, this is close to Mill Avenue. Shady Park is not on Mill Avenue, to be clear. But it's something the court, in its discretion under the McQuaid factors, looking at the locality and character of the surroundings. I see my time has expired. We ask that this court affirm below.
Thank you.
Thank you.
I'd like to make a quick point where Mr. Jarvie left off. If the Superior Court, it's all about framing, right? Where the area is measured. If you put this narrow box there, then there may be a residence here and here Shady Park. But if you accept what the Superior Court found, then the Las Vegas Strip is a residential area because it has some hotels and there may be a house over here. The fact is that the court had to consider the evidence in determining, because context is so important in the area of nuisance law, and there's no evidence, and the order is clear that it did not consider it. It rejected the evidence from every single person who testified because they had the label, the city of Tempe. And I want to address, Judge Morse, your point in our brief that the court was very clear in its closing instructions after the trial concluded, and just briefly, on page 6 of our reply brief said, we quote him, and he said, "There's nothing in the request that's before me or the filings or the pleadings that ask this court to shut down live music at Shady Park." The court couldn't have been clearer, so there was no issue with the First Amendment until the injunction came out.
Counsel, Judge Brown asked, and we are a little, we should move faster, but sometimes the wheels of justice turn slowly, and assuming we can reach an agreement among the three of us and get a decision issued, it's probably going to be into January before we can get anything out the door. How does this interact with what's going on in February?
Well, first off, there's a lot in play. I don't necessarily, we are scheduled for trial, but there's issues about whether or not, depending on how the disclosures go, will there be, and motions, will there be a jury, will there not be a jury, will we proceed? There may be more motion practice. So I agree there's currently a trial scheduled at the end of February, but that trial may or may not go forward. And if for some procedural reason or scheduling reason it doesn't, then this absolutely matters. But even if we are going forward, your statements matter, because right now we have a new judge who's seen an order of an old judge. There's a violation of the First Amendment, and every single day matters. Every day my client's doors are closed, his revenue is gone, the business is threatened, the people who work for him are threatened with their jobs. The area, it matters every single day. And so even if we're starting next week, I would say to you, this isn't academic. What you say, and obviously we'd like you to say it as quickly as possible, and we'd like you to agree with us, but every day matters. It's not simply we have a trial and maybe all this becomes moot. So that's what I would say about that. And the last, in the few seconds I have left, the last point I want to make is that this is not comparable to the situation of in Matson. This is a complete ban on speech. We cannot play music outdoors. And this idea that we could, well, simply move it indoors, you're right, there's no evidence in the record to suggest that. Our stage is outdoors. And lastly, I want to point out that it's not just 11 o'clock, right? It's 7 o'clock on Sundays. And the evidence at trial was that there's a significant amount of revenue that comes from the brunch crowd. So 7 matters.
Thank you, counsel. We appreciate your arguments and time. We will issue our decision in due course. And with that, court is adjourned.